So how should the judiciary coexist with the libertarian government? And the first time that I read this topic, I was really surprised. It sounded really big, and again, these panels offer just perspective, and it's an opportunity for us to open up these conversations and these discussions. So on today's panel, we want to explore how an independent judiciary system should function within a libertarian framework, ensuring liberty, limiting state overreach, and making government accountable as well. So I want for each of you to take 1 minute to explain your own connection to the judiciary system and why this topic matters. We can start with you, Silvia.
Bueno, muchas gracias. Yo voy a hablar en español. Les agradezco mucho la invitación, especialmente a Ana Caprat, que siempre ayuda mucho a los libertarios. Yo en realidad soy profesora en la Universidad Nacional de Rosario, ¿sí? Es un lindo tema esto del Poder Judicial y un gobierno libertario. Antes que nada, ¿qué hace el juez? O sea, ¿qué es la actividad jurisdiccional? Es resolver conflictos intersubjetivos de intereses aplicando el derecho, aplicando el ordenamiento jurídico en general. Para un liberal clásico, el Estado tiene que ser un Estado austero y la función esencial es defender los derechos individuales. Ahora, funciones esenciales del Estado para el liberalismo clásico, justamente una de ellas es la justicia, otra la seguridad. Ahora, si vamos ya a un Estado más libertario, tendríamos que analizar, y esto estamos muy imbuidos en nuestras neuronas de ideas socialistas, la posibilidad de separar más el derecho del Estado. Y como bien nos enseña Ricardo Rojas, yo leí un libro de él, Fundamentos Praxeológicos del Derecho, que realmente me sacó del cerebro muchas enseñanzas de la facultad. Yo creo que hay que darle mucha primacía a la autonomía y la voluntad de las partes. Las normas de orden público lesionan la libertad. Por eso, por ejemplo, en Santa Fe se ha puesto la mediación obligatoria previa al juicio, que en principio, como yo soy liberal, no me gusta que sea obligatoria, pero sin embargo ha dado muchos resultados. ¿Por qué? Porque un mediador, un árbitro, toma el tema de la justicia de otra forma. No está tan imbuido de tantas leyes. Fíjense que la ley es una norma general y obligatoria, pero tiene que tener certidumbre. ¿Y qué pasa en Argentina hoy día? El legislador cambia las leyes todos los días. Yo soy diputada en la provincia de Santa Fe y lo sufro realmente increíble. Las ideas socialistas coartan la libertad. Por eso creo que en definitiva lo mejor sería separar el derecho de la política. Eso sería lo mejor para realmente lograr una justicia rápida, eficiente y que dé respuesta a los conflictos de las personas.
Gracias, Silvia. Marcel.
Sí, muy buenos días. Good morning, everybody. It's a pleasure to be here. Thank you so much for having me, Paul, Silvia, and Maria. Pleasure to be with you in this panel. Well, I have firsthand also experience with lawfare in Brazil right now, coming from the judiciary. I could talk about the censorship against myself that I suffered and investigations by the federal police of Lula ordered and authorized by the Supreme Court. But I would start by saying something that most of you probably don't know. Today, there are about 400 Brazilians as political refugees here in Argentina. Victims of lawfare, victims of a process that started after January 8th in Brazil, which was similar to what happened in the United States on January 6th. People who were protesting, mostly peacefully, they were put in jail on the January 8th and 9th. And after being put in jail, I have here the work of a journalist, Michael Schellenberger, and two Brazilian journalists, David Agapi and Oliveira Jr. They released some leaked WhatsApp messages. And just to start with, I think it's important to read what is in this message. The chief of staff of one of the justices, Justice Alexandre de Moraes, the one who was just sanctioned by President Trump, maybe you've heard about that, for violating human rights. The chief of staff sends to one of her assistants, Eduardo, could you please get me that report for these 20 cases? That's 1 month after they're being put in prison. The Prosecutor General's office requested provisional release for them, but the justice doesn't want to let them go before we check if there's anything on social media. So many people would be kept in jail and are now convicted only for posts they had on social media against the government, not because they broke anything, not because they engaged in vandalism, just because of their political opinions. And the very fact that I'm here in Argentina right now talking about this can put me in Brazil into investigation too for what they claim to be obstructing justice or trying to help people who are outlaws in another country who fled the Brazilian jurisdiction. So I'm here talking about this because I think you must be aware of what's going on in Brazil, and because I still believe in justice, and we're going to fight for it. Thank you.
Thank you, Marcel.
If I remember the question, it was about how does the judiciary, how should they react or act with a libertarian administration?
What's your connection to the judiciary and why this topic matters to speak about on a libertarian government?
Well, I'm personally connected with the judiciary by having fought against them for 30 years in courtrooms. I've had a lot of personal experiences, and my experience tells me that judges typically are the tool of the state. They're not typically out to protect any individuals. In fact, they acquired their positions by appointment by political figures. They were appointed by presidents or governors or ministers or something, and they didn't get appointed until they were politically correct. So they had to be people who were trusted by the political machinery that runs the state, that runs the government, or they would never have become judges. That's true certainly in the United States. It's true in the individual states in the US, except for a few where people have the right to elect judges, and I don't believe that's a system that works well either. I don't know the systems that well in Latin American countries, but as I understand it, judges get more involved, for instance, in Latin American countries in criminal cases than they even do in the US, because you still have an inquisitorial system in most of the countries in Latin America, which means the judge participates in questioning people in trials, and the judge decides whether they're guilty. There are very few areas where people have the right to jury trial. And in the US, our jury trial system has been destroyed by the prosecutors and the justice departments, and with the cooperation of the judges, not with the resistance of the judges. So I would say that my experience, judges are part of the problem. They are maintaining the power, they're extending the power, and they're exercising their own power. And so we don't have an experience in the United States with regard to the question we were given. We don't have any experience with dealing with a libertarian administration. We have Donald Trump, but that's not it.
Thank you, Paul. So this is, as we can see, key in the defense of freedom. And so we need to talk about also independence and accountability. And you all said, so how can we stop courts from being politicized? And also, how do we keep judges independent but not unaccountable?
Un tema interesante, el tema de la rendición de cuentas. ¿Por qué? Decíamos que el juez es un tercero, imparcial e independiente. Entonces, para asegurar esa independencia, si se rinde cuentas, el juez ya estaría supeditado a otro que tendría que aprobar esa rendición. Por ejemplo, en Argentina, la selección de jueces, que es un tema muy importante, se hace a través de un procedimiento, diría, semitécnico. Porque los jueces de la Corte Suprema los propone el Ejecutivo al Poder Legislativo, ¿no es cierto? Ahora, los jueces de las instancias inferiores, en Santa Fe también ahora se está reformando la Constitución de Santa Fe, y es muy probable que en Santa Fe, yo estoy como convencional constituyente, están arruinando la Constitución de Santa Fe, va a ser un panfleto socialista asqueroso. En Santa Fe se crea un Consejo de la Magistratura, que es un órgano que hace como un concurso de los aspirantes a jueces, y los primeros tres, o sea, las primeras 3 notas de esa terna, se le da el poder discrecional al gobernador de elegir uno de esos 3, o sea, puede elegir al primero o al tercero y proponerlos en asamblea a la legislatura. ¿Y cuál es la cuestión acá? ¿Cómo se compone ese consejo? Yo no veo mal que exista cierta participación de los otros poderes en la elección del juez. Ahora, Si a ese Consejo de la Magistratura se le da un porcentaje importante político más que técnico, ahí ya tenemos el primer problema. Ahí entra mucho la política a incidir en el juez. Incluso nosotros en el proyecto, en la convención, queremos que en ese Consejo de la Magistratura no haya ningún representante del Poder Ejecutivo porque ya el gobernador tiene suficiente poder con elegir de la terna. Nos parece que eso es suficiente. Pero realmente la politiquería se inmiscuye de una forma totalmente indebida. Para que tengan una idea, hace poco, allá en Santa Fe, el gobernador Puyaro había hecho un decreto donde preveía esto de que haya un concurso para elegir a los mejores jueces, y como en ese concurso sus amiguitos no ganaron, no llegaron, desaprobaron, no es que no llegaron a la terna, directamente desaprobaron, dejó sin efecto todo y propuso a la Asamblea 2 que habían desaprobado el examen. Son jueces de ejecución penal, o sea, los que se dedican a controlar cómo se cumplen las penas privativas de libertad. Y se nombraron eso. ¿Y yo qué dije en la legislatura? Que en la politiquería buena, en la política buena, sana, que para mí existe, pero que casi está reducida, cuando se elige un juez, todos los legisladores vamos a aprobar la designación por unanimidad, vamos a aplaudir y vamos a decir, llegó a juez una persona que realmente se lo merecía, que ha escrito libros, en mi criterio también que haya litigado, que conozca el fragor de lo que es un juicio, y que todo por unanimidad, más allá de las ideas, porque todo ser humano tiene ideas políticas, que todo, digamos, se merecía ser juez, culmina su carrera siendo juez. Y no esta gente que ponen, que son amiguitos del poder, porque después esa gente en la Corte Suprema, ¿qué va a hacer? Va a avalar las medidas absolutamente inconstitucionales y que violan la libertad de todas las personas. Por eso yo creo que es muy importante el tema de cómo seleccionamos a los jueces. No me parece que sea una buena forma, como por ejemplo hoy se da en México y se da en Japón con algunos jueces de algunas instancias, la elección popular. Yo creo que se requiere de una selección técnica muy importante y guarda, porque a veces lo que se hace en el concurso, al examen técnico se le pone un porcentaje, pero después viene una entrevista personal y ahí los comunistas arruinan todo y nos ponen porquería en el Poder Judicial. Así que yo creo que eso es lo que más hay que ver, cómo se seleccionan a los jueces. Y después la rendición de cuentas es un tema muy embromado. ¿Por qué? Porque para mí el juez tiene que trabajar tranquilo, no tiene que tener ninguna dependencia de nadie. Yo en clase a veces digo de broma solo de la esposa, porque digo que siempre trae un gran hombre y una gran mujer, o a la inversa, ¿sí? Pero que no tiene que tener porque justamente tiene que ser tercero para cumplir su función bien. Por eso, lo de la rendición de cuentas yo no lo veo. El juez, si comete una irregularidad, mal desempeño o delito, habrá juicio político o, en su caso, si es de menor jerarquía, un jury de enjuiciamiento que se llama. Pero la rendición de cuentas yo creo que puede llegar a afectar la independencia del juez.
Gracias, Silvia.
Yeah. I will start with Churchill's phrase as a premise, like democracy is the worst system there is except for all others. So we have democracy at least as the best system there is. So if we look to the Brazilian case, and I'm sure it's more or less the same in other countries, justices of the Supreme Court, they are appointed by the president, but they have to be confirmed by the Senate. And if they commit any crimes, they can be impeached by the Senate. But what we see in Brazil is that the Senate is not doing a good job in confirming the appointments. Actually, is doing a pretty bad job in Brazil. We had the lawyer, the personal lawyer of Lula, appointed by him and confirmed by the Senate, and afterwards his Secretary of Justice, who was also confirmed by the Senate, who in the past was affiliated to the Communist Party. And Lula, after the guy was, Flávio Dino's his name, was approved by the Senate, in a rally said that finally we have appointed a justice that is a communist to the Brazilian Supreme Court. So the Senate is not doing a good job in approving, and it's doing even worse job in impeaching them, because at the moment we have 41 senators out of the 81 just over just the majority of the Senate in favor of the impeachment of Justice Alexandre de Moraes, the same justice who is persecuting, is the leader, persecutor and prosecutor of all these people that I told you about in the beginning. But the Senate, the president of the Senate, won't open the impeachment procedure because he's just friends with that guy. So going back to democracy and to the power of Congress, I think that Congress has been subject to many attacks from people who actually should be engaging more in politics. I'm not telling you to trust me. I know there's a lot of prejudice against politicians. We have to continue being very skeptical about politicians, and I am as well, believe me. But the fact that we have not been participating enough is making situation worse, also because those who are participating in politics are much more interested in their short-term personal goals instead of, you know, building really a institution like the Constitutional Court that is really accountable to what the Constitution actually tells them to do. So this would be my take on that. It's very difficult really to get out of that, but maybe we should go back and look to the beginning of the institutionalization of the legislative power, which was actually a form of the bourgeoisie, who were, to Marx's probably rage, the most revolutionary people in their time, who decided to gather in parliaments to put limits to the power of the kings. Maybe we should look at the politicians in Congress and legislative and engage more in politics in a way to make Congress stronger, to put limits on the executive and the judiciary branches as they did in the past.
Thank you, Marcel. Paul?
Oh, I'm sorry. In the United States, we have, I'm sure most of you know this, three divisions of our federal government: the judiciary, the legislative, and the court system. Excuse me, the judiciary, the legislative, and the executive, the President Trump. Yet they're designed to check the power of each other, and that doesn't work. So I don't believe that the judiciary, for instance, is a very effective check on the executive. For instance, our President Donald Trump, he continues to invent new ways to get around our Constitution, and he finds lawyers who will come up with arguments to support that, and he takes his arguments into the courts when somebody tries to stop him, and he typically wins in the courts. He wins at one level, or he wins at the higher level, or he wins at the Supreme Court. Ultimately, he wins most of those decisions. This says that he can ignore what the Constitution apparently says. So I don't believe the judiciary can restrain the president very well. And I think I'd like to go back and mention what is the judiciary and what is the role of the judge, because there are different kinds of judges, and that what they can do depends on what level they work, what kind of work they do. The judge who sits in a trial court and manages trials is a very different judge than a judge who sits on the Supreme Court or on a court of appeals and decides technical legal issues. The judge who decides the issues of justice every day in the courtroom is a person I think also needs to be focused upon, because they don't protect the rights and liberties of individuals very well, and there's no reason that they should, because nobody's making them do that. Nobody's watching the judges to see that they're protecting rights. Judges, when they're appointed, whether it be a trial judge or an appellate judge, intermediate, or the Supreme Court judge, when a judge puts on a robe, as some judges say, they all get what's called black robe fever. Their brains are overwhelmed with fever and the feeling that they're suddenly wise, they're suddenly intelligent, they suddenly have knowledge they never had before. No matter what comes in front of them, they can decide the issue. It may have done nothing but be handling business disputes, and suddenly they can handle complex corporate disputes, complex legal arguments, complex arguments about constitutional rights, about all kinds of things. They never could do any, they never knew any of that. They didn't understand contract law when they went to law school, but now they're interpreting multi-billion-dollar contracts and the meaning of contracts. They are not people who are experts in the Constitution. They never understood constitutional law in law school, but now they're deciding whether you have First Amendment rights to free speech or whether those rights don't exist. I personally have experience with that because in Colorado, at one point in time, I tried to put an issue on the ballot because in Colorado, the voters can propose a new law. If they can circulate a petition and get the people to sign it, they can put it on the ballot, and the people can vote a new law for themselves. But the legislature doesn't like that power reserved to the people, so the legislature passed a law which made it difficult to use that process. Well, I tried to organize a petition drive, and the legislature didn't like it, and the Secretary of State didn't like it, and the Attorney General didn't like it, so they threatened to put me in prison for exercising my rights to organize a petition drive and put this on the ballot. So I had to sue in federal court. We went to a federal judge, a trial judge. He didn't understand the Constitution. He didn't understand the First Amendment. He said, no, that you don't have any rights. Your rights aren't being violated. So we had to go up, higher court, eventually to the Supreme Court, where they accidentally got it right. And they decided that it should not be a crime to pay someone to go out and speak for you on political issues. Paid political speech should not be a crime. That's what they were going to charge me with and throw me into prison for. So it is possible to get a court to do the right thing, but you've got to go to every court that's there, and maybe you'll get lucky, and maybe you won't get lucky. But if you go into a trial court seeking justice, say in a business dispute with another businessman, or with an accident situation where you sue someone for hurting you in a car accident and you want justice, you go into court, you hope that the people will be honest, the lawyers will be honest, the witnesses will be honest, and you get justice, but you should never count on that. You should never assume that it will turn out correctly. And I've struggled with how can that system be improved, and what can you do with judges to help them achieve better outcomes. Well, the first thing is you have to take away their feeling that they have all the power, that they're always right, that they're never wrong. They need to be taught humility. And they're not going to be taught humility by a higher court. They're going to be taught humility by the people, if they're taught at all. So my experience is judges hate to be criticized. They hate to be criticized publicly. They hate to be embarrassed and called out for things that they did in their courtrooms. But I don't believe that can be dealt with by institutions. I think it has to be done by the population, by the people of the community. They have to speak out against judges who make horrible rulings, who don't protect people's rights, and there should be no respect for judges who disrespect the people.
Thank you, Paul. I think I could be sitting here the rest of the morning asking you questions, but we have 5 minutes left, so we're going to have some questions from the audience. We have 1, 2, and 3 here.
Thank you. Can you hear me now?
Yes.
Okay. First of all, thank you for a very interesting discussion. Please excuse my ignorance. People are doing this all the time, so I hope you'll excuse my ignorance. In the United States, we have what is considered a common law tradition, and that is juxtaposed to a civil law tradition. Again, I'm just ignorant about what goes on in Brazil, in Argentina, in Chile. Is there any common law tradition that essentially informs most of the legal proceedings, or is it more of a civil law tradition?
In Brazil, it's civil law, okay? We have, of course, rulings, or that are kept as a sort of a standard for the future, but it should be the law in a positive way that guide, the trials. But in our case, the situation is so bad that the justices, they are redefining everything that is in the Constitution. They just decide something completely different, sometimes the opposite as what is in the Constitution. For instance, I have parliamentary immunity for any, it's in the Constitution, of my words, votes, or opinions. That's Article 53 in the Brazilian Constitution. Regardless, this communist justice, Flávio Dino, authorized investigation against me because I did a speech in the House floor accusing a federal police agent of Lula of using false information which is proven to be false, to keep somebody in jail for 6 months. So this is just one example. We just have we don't have much time about it, but just to round it up, I think one of the worst things that we have now going on in Brazil is the judiciary deciding what is and what is not democratic, when Congress actually is the voice of the people. And the government should be monitored by the people and not be monitoring the people, as we see now in Brazil.
En realidad, siempre, en todo el mundo, las reglas surgen de la costumbre, no hay duda. Pero hay una gran diferencia entre el sistema nuestro y el Common Law. En Argentina, primero, bueno, cuando se sanciona la Constitución, la idea era limitar el poder. Esa es la función esencial de una Constitución. Para mí, una Constitución que organice el poder y lo limite cumple su función. No hace falta la Declaración de Derechos porque los tenemos sin que el gobierno nos los conceda, si no sería muy peligroso. Ahora, en Argentina comienza el tema de la codificación de las leyes. Y algunos sostienen que esto da más certidumbre. Muchos dicen que en Argentina, si los jueces se basaran en precedentes, sería riesgoso, le daríamos mucha libertad de decisión. Pero ¿qué pasó? Lamentablemente el legislador no siguió las pautas y los principios constitucionales. El legislador permanentemente sanciona leyes que violan la Constitución y que restringen la libertad individual. Eso es permanente. Entonces, quizás sea mejor otro sistema, quizás sea mejor, por ejemplo, en Santa Fe, en el Código Procesal hay un capítulo muy chiquitito de árbitros. Nombrar árbitros y que empiecen a decidir cómo, aplicando la costumbre, que es una fuente del derecho, aplicando hasta reglas que quizás las mismas personas en un contrato prevean el procedimiento y las reglas por si alguien incumple. Yo creo que ese sistema daría mucho más certidumbre porque lamentablemente la inflación legislativa es tan nefasta como la monetaria y quizás sea bueno un mercado de normas, dejar que las personas utilicen su voluntad. En Argentina se perdió un principio básico, que es que el contrato es ley para las partes. Hoy día eso está perdido. Y el reglamentarista serial, yo así lo llamo al legislador, se la pasa, por ejemplo, para que tengan una idea, en Santa Fe, hace poco se sancionó una ley de buenas prácticas agrícolas. Mira si el legislador va a saber más que el chacarero cómo manejar su campo. Vos lees la ley y en ningún lado dice nada, bla, bla, bla. Después crearon un registro de fideicomiso. No, porque es importante que el pueblo sepa quién es el fideicomisario, el beneficiario. Le digo, che, se hace por escritura pública, vos vas al registro y la pedís. Cuando hicieron esa ley, pusieron que el que entra al registro para escribir el fideicomiso tiene que ser un abogado y pagar una tasa, porque el reglamentador serial siempre hay una exención seguro, algo te extrae de tu riqueza. Y le digo, ¿por qué no pone que sea cualquiera el que entra al registro? Así le sale más barato. No, Silvia, vos pensás estar acá toda tu vida, vos sos abogada, cuando salga de acá no va a tener trabajo. Le digo, ¿vos querés que yo tenga trabajo coactivo o que me vengan a ver por buena abogada? A los 40 días vienen y dicen, che, hay que modificar la ley de fideicomiso. Le digo, ¿por qué? Se quejaron los contadores, vamos a agregarlo. O sea que vos ahí ves lo que es el legislador en contra de la Constitución. Un desastre.
I'm purposefully avoiding the cameras. You'll see why. I grew up American with all the protections of the First Amendment, and later in life acquired Brazilian citizenship. And so now I'm very careful when I speak truth to power over social media, even though I'm not living in Brazil at the moment. My question to Marcel, are the sanctions against Alexandre de Moraes, are they working? Is anything positive coming out of that?
Well, for those who don't know, Alexandre de Moraes, thank you for the question, and I'm sorry for you to being that careful, but you're right. I mean, many people in Brazil are careful about what they post on social media right now because they fear of being censored or even being persecuted or even being put in jail. You cannot question, for instance, the results of elections anymore in Brazil. If you do that, you're automatically banned from social media. So Justice Alexandre de Moraes is the main justice behind all this persecution in Brazil. And he also happened to be the justice who decided to block X in Brazil last year. So we worked together with only Russia, China, Iran, and other 2 or 3 countries in the world that blocked entirely the access to X in the world. So he also decided to censor American citizens or Brazilians who became American citizens, like you did the other way around, right? Who are in American soil. And this is why he's being sanctioned now by the United States with the Magnitsky Law, which is a law that is actually, it's called the how do you call it? Financial death penalty. It's like you cannot have any bank accounts in the United States, all assets you have there are frozen, and you can't have any commerce or trade or business with American companies either. So he cannot have a credit card basically in Brazil right now, like happened to many other people, like in Hong Kong, for instance, recently as well. So I think it is working because other justices are now afraid that it can come to them. Actually, the president of the court, who is one of the guys who are also behind Alexandre de Moraes and giving his support, has started to talk about leaving the court in about 1 or 2 months and retiring early because he's also afraid of getting that punishment. Press just revealed that he has a 22 million reais, about $5 million house in Florida. So, and he doesn't have a visa anymore because Trump also put sanctions in 8 of the justices, so they don't have visas anymore to go to the United States, and their family also don't. But on the other hand, it's also like an atomic bomb because these guys are already crazy psychopaths, and now they become also a mad dog too because Alexandre de Moraes doesn't have anything else to lose. So it's a very difficult situation. If you look around the world, sanctions have helped to some extent. What we have to really do is get it fixed in Brazil. This is why I'm in politics there too. It's very difficult to get more people involved in politics, but my opinion is next election, 2026, are the most important in Brazil and maybe the last. Like we saw the case happening in Venezuela, we have to put all our efforts in 2026 in the elections and not do the same as the Venezuelans did, boycotting the process at some point. And Argentina is a great example because Milei just prevented you to become a Venezuela, didn't he? So, I mean, for those who are from Argentina, I believe in my country, and it's a very difficult moment, but we have to get through it, and may God help us. Thank you.
Thank you. Last question.
Is the solution a private judiciary?
That's been tried too, and those people were sent to prison in the United States. There were some who tried to set up a private judiciary, private legal system, and they were all indicted and sent to prison.
So you don't want to be in favor either.
El problema respecto del Poder Judicial privado, yo decía, bueno, que las partes, cuando celebran un contrato, por ejemplo, establezcan el procedimiento a seguir si hay una controversia, ante quién van a ir y cómo se va a resolver. Lo único que a mí me hace ruido, me encanta lo privado, es la ejecución de la decisión. Porque, en definitiva, muchas veces ese que decide, la materialización de su decisión, de su resolución, va a implicar el uso de fuerza. Y bueno, ahí yo creo que hay un punto a considerar. Muchos dicen que si se hizo todo por consenso y hay respeto, se va a acatar hasta más, no por miedo al gobernante, sino por respeto de haber hecho ese acuerdo. Pero ahí puede llegar a haber un problemita respecto de la ejecución de la decisión.
Gracias, Silvia. Paul, Marcel, Silvia.